Hello, I'm Angela Princewell. Thank you for joining our webinar today on spousal support principles. In this webinar, we will cover as much as we can within the 30 minutes that we have. We're going to be talking about our spousal support. What is it? What are the objectives of spousal support? Who is entitled to spousal support? What is the basis of entitlement? And the range of spousal support. Where do you fall within the range and why? We'd also look at the duration of spousal support, and then we go into the biggest misconceptions to spousal support. Why can't you see? Hello, everyone. Looks like we had some technical difficulties. I'm unsure why. It appears some people cannot see my screen, and I'm not sure why. Is everyone able to see my screen? If you can't, if you could just type in a quick question at the bottom so that I can look into that. But at this point, I'm really not sure why that's happening. But hopefully it's just happening to one person, and I hope the rest of you are able to view this this webcast. So I'm going to start over and thank you for logging in to our webinar on spousal support principles. And our webinar is going to cover what is spousal support, what are the objectives of spousal support, who is entitled, the range, duration, misconceptions, and common pitfalls in calculating spousal support. We would also talk about exceptions to the spousal support advisory guidelines. And if you don't know what that is, in a minute you will. And you know but in a nutshell, it's what kind of exceptions are available to you if you need to either get more or less spousal support than what the calculations introduce. So it's a lot of information that I have to give to you, and you need to understand that this webinar is not a substitute for independent legal advice. It's important that you talk to your lawyer and get your lawyer's advice on how to apply these concepts to your specific situation. But we'll just discuss a lot of high level, concepts on how spousal support may apply in your situation. So a little bit about me. I was called to the Ontario Bar about 12 years ago, extremely passionate about family law, work with a fantastic team of people who share our vision of just helping make people's family lives better. And as a result, the last 5 years, we've won top family law firm in Durham region. We're highly rated on Google and other online platforms. And we really appreciate our clients because they make that happen. But for us, it's just a reflection that every day we're striving towards being better, and that, we're our clients. It's nice to get that sort of high five from our clients that we are, reaching our goal of just helping make their family problems a little bit better, at least the legal part of it. So let's dig right into it. What is spousal support? It's just simply, financial support from one partner to another when a relationship is over. In some places, it's called alimony. It's spousal support in Ontario, and it's a legal obligation because the legal system sees support as, or sees marriage or common law relationships as a partnership. So when it dissolves, there's obviously consequences to that, and there's some of those consequences are financial. And so spousal support comes in to help the other party that has less financial wherewithal to be able to get by following the breakdown of a relationship. So that's really simply what it is. And so when you look at to claim spousal support, you have to be claiming either under the Divorce Act or the Family Law Act, and their purpose and objectives of spousal support, reflect what spousal support really is. So it tries to apportion the financial consequences that have arisen as a result of the breakdown. It recognizes that spouses would have would have suffered some sort of disadvantage, while another person would have gotten an advantage in the relationship, and spousal support kind of helps to balance that scale. If there is an economic hardship to one spouse as a result, the idea is that spousal support would help to relieve that economic hardship. And lastly, the purpose is also to help promote the economic self-sufficiency of the partner that's lower, that's earning a lower income. So who is entitled to spousal support? A spouse. It's that simple. But who is a spouse? If you're any two people that are married to each other are spouses. Under the Family Law Act, a spouse is, well, in addition to being married people, it's also two people who are not married but have cohabited for a period of not less than 3 years. So at least 3 years or more, or are in a relationship of some permanence if they are the parents of a child. What that means is if you were in a relationship for just a year and you have a child together, then you will qualify as a spouse under the Family Law Act, and you could potentially be entitled to spousal support. But if you don't have a child and you've only been in a relationship for 2 years, then you may not be in a position to claim spousal support. Let's talk about the basis of entitlement to spousal support. So there's 3 main heads under which a person's entitlement to spousal support could be had. So first, you've established that you're a spouse, because if you're not a spouse, then the inquiry ends there, right? So you are a spouse, and it's usually a scenario where there's 2 incomes and one person is earning more and now needs to support the lower income earning spouse. And now we have to go on what's the basis of this entitlement to spousal support. It could either be compensatory, needs-based, or contractual. So compensatory spousal support just includes scenarios of it's usually long-term marriages, and obviously these are not exhaustive lists, just giving you ideas here and there. A partner staying home full-time to care for the children, that's in a long-term relationship, that could potentially be a compensatory basis for spousal support. If you have the care of the children after the relationship, if the family moved and one person had to subordinate their career just to encourage the other person, or if you had to support the education or training of a party, then those could be factors that could entitle you to support on a compensatory basis. The more of these factors that are in your favor, the stronger your compensatory claim for spousal support. So support could also be needs-based, and sometimes just purely as a result of the length of the relationship. When it's now over, you're suffering a drop in the standard of living. So it doesn't necessarily needs just doesn't mean that you're suffering an economic hardship, even though that clearly is a need. But just a drop in the standard of living for the claimant to spousal support is a factor, because as I had said earlier, it's a partnership, and if now you're now moving from having the benefit of 2 incomes to just your income, and you're in a lower income earner, and you lose that standard of living, then that's a needs basis for getting spousal support. And lastly, there's this contractual basis, so which includes formal contracts, your cohabitation agreement or marriage contracts, and it also covers verbal agreements. So if the parties had agreed to support one party first, so that person goes through school, and then maybe later the other party was supposed to also get the support of the family to go through schooling, and now the relationship is dissolved and they don't get the benefit of that, you will have spousal support could be issued to kind of balance things out, so that the other spouse can get education and potentially become self-sufficient. So I will be sharing my screen with you, so we could run through some potential support calculations together. Give me a second here. So in this scenario, we're looking at, I have two support calculations open. So in this, the first one we're looking at is John and Jane Doe. They're actually both John and Jane Doe. And in this calculation, John earns 93,000, Jane 30,000. And if you look to the right, you would see that the calculations provide, it's a range. At the very top where it says child support guidelines, you would see that child support is more of a static number, right? So there is, table amounts, and I'm not going to go into why there's child support on both sides because we are discussing spousal support today. But the main difference you would note is spousal support has a low, mid, and high range in there. What the ranges mean is where it's just showing how much are you entitled to get. So is it the low, mid, or high? And there's usually a lot of conflict on this issue, as you can imagine. And that's where the basis of your entitlement to spousal support comes into play. If you're entitled to spousal support on a compensatory basis, then you might be having support at the higher end versus a situation where it's a very weak compensatory claim or it's just purely needs based, and then it might, you might find your support kind of going lower. So the factors, we've gone over the factors that form the basis of your entitlement to spousal support. And in addition to that, you can also, introduce various factors like the standard of living of children that are involved, right? You have to look at, are there access costs that can offset the amount of support that you should pay? And the whole idea clearly in this situation, depending on what side you're on, if you're the support payer, you're clearly looking to pay at the lower end, while the recipient is going to be arguing for the higher end. And at the end of the day, the role of the court or the mediator or arbitrator is to look at the factors and say, what's the basis of entitlement to this person's support? What are the factors for or against? And just kind of decide where each party or which amount is more appropriate in the circumstances. I want to point out that a lot of times people think that they should end at the mid-range. This is not necessarily accurate. It might be appropriate, but the mid-range is not just the sort of the default compromise. All of the factors that form the basis of a person's entitlement and just other external factors as well in the party's circumstances should really be looked at closely when picking a location in the range of the guideline amounts. Different factors affect what the child support amount should be. In this first calculation, you can see that the children, Carol and Michael, have a shared parenting arrangement. And in this other scenario, you can see that the children just live with Jane alone. And so in one scenario, in calculation 2, you have in this case, because the support amount that John's required to pay is $939, there's more of an amount for him to, and there's more spousal support that's payable versus the other, and I'll keep toggling between screens, and sorry if that really makes some people dizzy, but I couldn't figure out how to have them both at the same time, so that's why. And so in the second scenario, you see it's 0, 0, and then 377 at the high end. So you want to pay attention to, the income amounts that are being entered. The fact that this calculation is with child support, it would have, an effect on the amounts. The length of the marriage is something I want to talk about because a lot of times people have cohabited for a while before they get married, and you must understand that the length of cohabitation is what counts, not the length of the marriage only. So if you live together for 2, 3, 4, 5 years before you got married, you want to put in the date where you started living together, and that's what spousal support is based on, not when you got married. Obviously, the longer the relationship, the more likely you would be paying more in spousal support. In this calculation, it's 14 years, and you can see here where it's 20 years, it also affects the numbers. Duration of spousal support is a big factor. And by duration, it just means how long would you have to pay spousal support for? And this depends on a lot of factors, right? So are there children involved? How long was the relationship? That sort of thing. So if you look here where Jane and John were cohabiting for 20 years or married for 20 years in this case, you would see that it says that the formula results in a range of spousal support, and it gives the amounts for an indefinite duration. But if you go to the other calculation where it's 14 years, it does say indefinite, but it gives a maximum duration of 14 years. So that's sort of where the duration, or how long people often ask, how long do I have to pay spousal support for? Well, it depends on the length of your relationship and if there are children involved, their ages and things like that. It's important to also, and I'm going to just go into some of the misconceptions because it would help as we talk about these calculations. So biggest misconceptions regarding spousal support. A huge one is people say, how am I going to be able to afford this? And it's sad, it's heart-wrenching. We recognize that in trying to apportion the financial consequences of the relationship, that a lot of times both parties end up being in a worse position financially as a result of the breakdown of the relationship. And that's just, it's unfortunate, but there's really just no workaround to that. But on the bright side, there is spousal support is tax deductible, at least a portion of it. So you don't pay the spousal support out of your net income. I always advise clients to take the separation agreement or the court order to the employer so that the source, the taxes that are being deducted at source is reduced to allow for better cash flow. So on the other side of this as well is people sometimes request that spousal support should be calculated based on their net incomes, and that's that really skews things up. So in this example, John Doe and Jane Doe's incomes are their gross income, and that's really, you have to use the right income for that. It's their gross, not their net incomes. And in calculating the amount of spousal support that's going to be paid, the various tax positions are considered. And if you even go to the bottom of this page where it really sort of breaks down the calculations, you would see that the net you would see how it's factored in the taxes and deductions and all of that to come to a final figure. And in some cases, when I show this to clients, they kind of see that it may not be all doom and gloom, right? So just always take advantage of that, and always, try to reduce your taxes at source so that you have more cash flow. The other misconception is regarding child tax benefits. Child tax benefits do not form part of your income, so do not include them as income there. It's not income for spousal support purposes, even though it is available to the recipient for use for the children. Now, when another part that really trips people up is indefinite versus lifetime. So in this scenario, there's at least a maximum duration that's been generated. But if we go back to the other calculation, it just says indefinite. And most times when people see this, and because it's a 20-year marriage, it's usually both sides think, well, I'm getting support forever. Well, there's no such thing. You're not, well, except you negotiate it, of course. But indefinite duration is different from lifetime. It just means that because of the length of the marriage, there'll be no end date. If there has to be an end, it has to be based on a material change in circumstances. And, if you meet that threshold, then support can be terminated. So just make sure that if you're a support recipient, don't think that you would necessarily get the support for your lifetime. It may be that, but often it isn't. Another misconception is that a partner's high income disentitles them from getting spousal support, and that is not true. the fact if there's still a huge disparity in the incomes, it doesn't matter how high the recipient's income is, they will likely be entitled to spousal support. Now, another thing to note is an inability to pay spousal support is different from no entitlement to spousal support. And if you remember, we went over entitlement earlier, where we talked about compensatory and needs basis and contract basis for getting spousal support. Well, if there's a basis for entitlement, if the person is a spouse, if there is a disparity in incomes, and if there's grounds even after that for them to get spousal support, then the fact that the calculations generate a zero amount just shows an inability to pay. So if I go to this version of our calculations here, you would see that because the children are residing primarily with Jane, that John has to pay the full table amount of child support. And when he does that, in the ranges, we have a 0, 0, and then 377. So if the courts find, or if the factors point to, Jane only being entitled to spousal support in the mid-range, then that means she gets 0, right? But it doesn't mean she doesn't have entitlement to spousal support. In this case, it's pretty clear to see that Jane would likely be entitled to spousal support because it was a 14-year marriage, and now she still has to take care of the children even after separation. What this means is that at this particular point in time, John doesn't have the ability to pay spousal support, but it doesn't take away Jane's entitlement. So what may happen is, because Carol and Michael are, 4 years apart, maybe when John stops paying child support for Carol, there might be some ability for him to pay spousal support, or when child support ends for both children and things like that, he might have, there might be ability to pay spousal support there. So don't let that confuse you. Remarriage or repartnering does not mean an automatic termination of spousal support. Many people think that, but it's not the case. It may be a factor that could constitute a material change in circumstances if they now have a higher standard of living than you do. But in many cases, especially in longer term marriages where there's a strong compensatory basis for spousal support, the fact that one partner has remarried and now has access to even a higher standard of living may not be grounds to terminate spousal support at all. Retirement as well does not mean automatic termination of spousal support. It may or may not be a material change in circumstances depending on the situation. It may not even mean a reduction of your spousal support, and that really surprises a lot of people, because for most people, when they retire, they have a lower income, and they think, well, at the very least, like, support should be recalculated to reflect the fact that I'm no longer making the amount that I made pre-retirement. It's not an automatic, and there's many cases where people have retired, they're at maybe half the income they used to earn, but they're still required to maintain spousal support based on what their pre-retirement income was. So you want to be very careful there, and it requires planning and obviously speaking to a lawyer to make sure that in your situation, either support gets terminated or at least varied downwards to reflect the reality of your situation. And there's also cases where if it appears that you will still have to maintain support at the same level as you did before retirement, then maybe that could change a person's mind about retiring, or different kind of planning, or even renegotiating the entire agreement may be appropriate at that time. So very quickly, we'll go on to pitfalls in calculating spousal support. I'm going to go back to the income at the very top. Use the correct income. And in this case, I'm not just talking about what I said earlier regarding using your gross versus your net income. At this point, I mean characterizing the income properly. So John and Jane, in this case, are both employees, so that's great. We have employment incomes, but in some cases, maybe John's only getting rental income, for example. So you have to enter, you have to let your lawyers know the right characterization of your income. If you're earning your incomes in just dividends, for example, it would get factored in differently in the calculations, and it could really skew up how the numbers appears. Again, if you're if you're also self-employed and things like that. So point is characterize the income properly to make sure that the numbers generated are accurate. ODSP, which is the Ontario Disability Program, and Ontario Works are not to be treated as income for spousal support purposes. So if Jane Doe was receiving $30,000 in ODSP payments, we will have $0 for her income in the calculation, so that it doesn't skew up the numbers. The length of, and I touched on the length of cohabitation, that's a common pitfall. Just make sure that you use the length of cohabitation, not the length of marriage, in determining the duration and amounts for spousal support. At the left part of the screen, I'm just going to hover over it a little bit. You see where it says special expenses. Special expenses are expenses that you pay towards the children that's over and above your child support amount. And I mean, a typical example would be post-secondary expenses, for example. Make sure you give that information to your lawyer, or you factor it in yourselves if you're calculating spousal support. If you don't take into consideration these extra expenses, like even very expensive sporting activities for children, for example, that's a special expense. Daycare costs, that's a special expense. You need to put it in, and it needs to be factored into your support calculation. Otherwise, you would find that you're overpaying spousal support. So a lot of you would not have access to the program to do these calculations, but your lawyers will, and it's important that they get the information from you so that the numbers they're generating is accurate. And you want to look at, if you're looking at lump sum spousal support, a lot of people just want a clean break. They want to pay the spousal support out in a lump sum and be done with it. But what I find that a lot of people do is they would look at the monthly amount, they would multiply it by whatever number of years. So let's say in this scenario where it says 14 years, John may take $377 multiplied by 14 years and pay Jane Doe a lump sum. If he does that, he would have overpaid for spousal support, because as I mentioned earlier, spousal support is tax deductible, and by just giving that lump sum, you overpaid, because you don't get that tax deductibility. So the way to deal with that is to discount it for taxes. And if this is done using divorce mate program here, you would see at the bottom, where it says the spousal support lump sum, you could see it has a midpoint, after tax cost to John, and things like that. So if you're doing it yourselves, again, you could, it's something that you have to pay attention to and make sure that you factor that in. You want to also think about security for support. And that's just, if you're looking at our calculations here, it's just right there above the spousal support lump sum amounts. So the life insurance is very important, because in this example where Jane is making only $30,000, if anything were to happen to John, she no longer would be able to get the child support. Or if she were also getting the $377, that's over, that's about $1,700 that Jane might really need to be able to live on a day-to-day basis, that she no longer has access to, because John has now unfortunately passed. And so that's why life insurance is important, to be able to secure spousal support. So make sure you pay attention to that, and just make sure that when you're negotiating your spousal support, that you factor in security for support. And lastly, we'll talk about exemptions to the SAGS formulas. And by the SAGS, I'm talking about the ranges here, the spousal support advisory guidelines. So if we go back to this example, so what are some of the exceptions? So if for whatever reason, the numbers here just aren't working for your situation, you think it's too high, you think it's too low, you may be able to ask for an exception. And it's very rarely done. There are very limited factors, but there are factors. So if for example, John is living in Mexico, well, in Mexico, there's no tax deductibility for spousal support payments. So he may be able to ask the courts in Ontario to reduce the amount of spousal support that he has to pay to account for the non-deductibility. If John has, a prior support obligation, there's just no way he may be able to make paying the full spousal support amount in this case. He can ask for an exception for that. If John left the relationship with a lot more debt, and in this case, we mean a debt after equalization is done, if the debt has to exceed the asset. So, because usually debts get factored into the equalization process, but if the parties have way more debts than assets, then it may be grounds to, and one party has to carry those debts and make payments on them, that would clearly affect their ability to pay spousal support, and they would have to, they could ask for an exception for that. So there's other exceptions, illness or disability, if there's just, in a situation where spousal support maybe comes up with a 000 range, but Jane Doe just cannot make do with just getting $939 a month or something like that, then she can, she can claim basic hardship and also get a higher amount than the ranges might be producing. So that's all we have time to cover today. I hope this information has been helpful to you. Do reach out to us if you have any questions or need help with your spousal support matters. Otherwise, I hope you could just take these tools, these principles, apply them to your cases, and I hope that we can help. We've been helpful in helping you resolve any conflicts that you may have on this issue. Take care and join us next month for our other webinar.